Centuries ago, in order to commence a proceeding, a person had to file in the court a writ, which was a very formal written document requesting the court to exercise some specific power. These writs had to be exactly right, or else the plaintiff would lose, even if justice was clearly on their side. Most people were illiterate anyway, but even among those who were not, in order to get the writ exactly right, expert support was required. Those experts were the foundation of the legal profession. Certiorari is one of those ancient writs. It's a Latin word from the same root as our modern English words certificate and certify. The word certiorari means we are to be informed. So the writ of certiorari is a writ by which a court calls a matter before it. The court says, we are to be informed about this dispute. Hilton and Lawson is one of the earliest examples. It occurred in 1559 in the reign of Queen Elizabeth I. There was a dispute between the parties about the ownership of land. The Hiltons, father and son, had what was called a life estate in some land in Durham in the north of England. Life estates were often challenged by whomever owned what was called the reversionary estate, which was the underlying title. None of that really matters. The point is that they were involved in a land dispute in the far north of England. Mr. Hilton Sr., described in colourful terms in the case report as an old diseased man, no longer lived in Durham. Instead, he lived in Middlesex, which was then a separate town to the west of London, a long way from Durham. In the 16th century, it would have been very difficult for him to get to Durham to defend against the challenge by the Lawsons. And so the Hiltons went to court in London and asked to have the matter moved to London. The court said, a certiorari is granted, directed to the Chancellor of Durham to certify into this court the whole matter depending before him. Later, certiorari mainly came to be used in administrative law as a way for courts to call government decisions before the court for review. In Australia, certiorari remains a theoretical possibility, but most administrative review now occurs in accordance with a statute, the Administrative Appeals Judicial Review Act.